كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's a wonderful initiative.
The GlobalSouth network opened new horizons for judicial cooperations.
GlobalSouth network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The GlobalSouth Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Good afternoon, everyone. It's my pleasure to welcome you to the 33rd seminar in Phase 4 of our International Interdisciplinary PhD in Progress weekly seminar series organized by the GlobalSouth Network. I'm Dr. Nouman Riayat, the founder and chief convener of the GlobalSouth Network. I've been organizing and running this series since May 2023. I am a lecturer in law at the Leicester Law School, and my research interests lie within the area of judicial independence, the rule of law, constitutionalism in developing democracies. I'm joined today by a discussant and a peer commentator. Dr. Nishant Upadhyay is the discussant for today's session. Dr. Upadhyay is the assistant professor at the University of Colorado. Dr. Upadhyay's research and teaching focuses on settler colonialism and empire, intersections of race, caste, and indigeneity, queer and trans of color studies, and South Asian diaspora. They are the author of Indians on Indian Lands, Intersections of Race, Caste, and Indigeneity, published by the University of Illinois Press in 2024. The book examines the interwoven and simultaneous areas of dominant Indian caste complicity in processes of settler colonialism, anti-blackness, capitalism, Brahminical supremacy, Hindu nationalism, and heteropatriarchy. At the university, they teach within the areas of queer and trans of color studies, theories and foundations of ethnic studies, disability justice, US Empire, and Asian American studies. Their teaching grounds: intersectional, transnational, abolitionist, and decolonial frameworks. One of Dr. Upadhyay's recent publications, titled Against Trans Inclusion in the Military, a Trans of Color Abolitionist Critique, published in Frontiers, a Journal of Women Studies. Lucrezia Perrig, PhD candidate at the Faculty of Social and Political Sciences, Institute of Social Sciences, University of Lausanne, is the peer commentator for today's session. Finally, I'm delighted to introduce our guest speaker for today's session, Diksha Sanyal, who is a PhD candidate School of Law, University of College London. Diksha joined the Faculty of Law as MPhil PhD candidate in September 2023. Her thesis aims to unpack the ways in which non-normative queer families in India navigate the legal system with the goal of developing a jurisprudential basis for their legal support and recognition. Her research is supported by the University College London Faculty Research Scholarship. Today, Diksha is going to present part of her PhD research titled Navigating Legal Borderlands, Love, Law and Live-in Agreements in India. Diksha, you will have 30 to 35 minutes for your presentation, followed by 5 to 10 minutes of comments and questions from our discussants. If time permits, we will then open the floor for a 15-minute Q&A session with attendees. The screen is yours, Diksha.
Right. Thank you. Thank you so much for this opportunity. I'm really excited to be in this panel. It's the most interdisciplinary panel I've been on. And it's always a little intimidating as a lawyer to kind of present to a non-legal audience, but it's also challenging. And yeah, it's also a good reminder for me to update my bio, because I think my project has undergone a massive shift, as you can probably understand, over the course of 2 years that I've been at UCL and doing this research. So, okay, without much further ado, let me jump into my presentation. So the presentation that I'm giving today draws, as I said, on my doctoral work that I've been doing over the last 2 years. And this particular study investigates this recent phenomenon that I've noticed of couples in India entering into live-in relationship agreements. These are, as the name suggests, agreements to cohabit together without marrying. Now, these agreements are drafted on a kind of affidavit, and they're notarized by public notaries. So they definitely look and feel quite legal and official. I'll as we go through the slides, I'll show you what some of these documents look like. But what's interesting about this practice is that these agreements are not really backed by any sort of statutory law, or they're not held as legally valid they're not considered as legally valid by any judicial order. So they're definitely not treated as a kind of valid, enforceable contract or a cohabitation contract, which is a very common practice in many jurisdictions across the world, right? So the paradox that I was kind of interested in was trying to understand why these agreements are being entered into when they're not entirely legally recognized and enforceable, right? So what purposes and uses do these agreements really have beyond enforceability? What purposes are they serving? And along the course of my research, I began to think about this practice. And as I started gathering more data on it, I began to think about this practice from the metaphor of a borderland, and which to me at least makes quite a bit of sense in trying to unpack what this practice is. Because as I explained and will explain through the course of my presentation, these practices are fit somewhere within the spectrum of not being illegal, but at the same time not carrying a lot of substantive legal value as well. So thinking about this as a kind of practice that exists on this legal borderland might help perhaps in trying to understand and piece together what's going on here. So I came across these live-in agreements really quite by chance, right? And I was looking through an open source database, and that's when I started looking at certain judicial orders that contain the term live-in agreements. And as someone who's taught family law in India and has had a little bit of litigation and practice experience, I was very intrigued by this agreement because I hadn't come across anything like it in India, at least. And so then, that curiosity soon became a rabbit hole, and I started to try and find more and more judicial orders that mentioned this live-in agreement to try and see what was happening here and what was this all about. And what I found was that I found several judicial orders actually mentioning these live-in agreements. So in total, I found about 369 such judicial orders. And the earliest of such orders was I found in the year 2010, and I collected my data up to December 2024. So over that time period, I found and located about 369 orders. Now, that number in and of itself may not seem like a huge number over a course of 14 years, but it's also not a totally insignificant number of orders as well. So I wanted to see and started mapping the patterns that were arising from this judicial data. And what I noticed is that predominantly these cases that mentioned such agreements arose in the northern and western parts of India, particularly in one state, and that's Rajasthan. So if you look at the map here on the left-hand side, the state that's highlighted, that's the state of Rajasthan. And that is where the highest number of orders were found. And as I note that in the table on the right-hand side as well, I found about 174 orders in the state of Rajasthan alone. And not only was Rajasthan really peculiar and interesting because it had the highest number of orders, but also the frequency of judicial orders mentioning these type of agreements was also had rapidly shot up in the state between the years 2020 and 2025. So using this data set, the judicial order data set as my guide, I started to sort of try and piece together how to study this practice and phenomenon, because not a lot has been written around this either. So since the state of Rajasthan is where most of these cases seem to be coming up, I decided that, okay, let me try and interview some lawyers from the state. So I searched through the judicial orders to find the name of lawyers who I reached out to, and I was able to schedule some interviews over the course of this year. And I've done about 16 interviews with lawyers who have been involved in either drafting the agreements or in litigating cases involving such agreements. And from these interviews, like I conducted semi-structured interviews with these lawyers. So through that, I was also able to get certain copies of the agreements, which I also analyzed. So about 7 agreements. And just trying to piece all these different data sets together and using a kind of grounded method, I've tried to come up with some sort of coherent picture, perhaps, of what's happening. So here's a picture from the field work that I did earlier this year in Jodhpur. And on the left-hand side, we see a picture of what this agreement looks like. So these agreements are drawn up on something called a non-judicial stamp paper affidavit. Now, if you're familiar with sort of the Indian litigation scene, this kind of document is a very easily accessible, commonly used document in India. And affidavits are used for all sorts of legal, administrative, bureaucratic purposes. And an affidavit is basically a device so that a person can make a declaration of fact on oath and present it as evidence, right? As I said, these are quite easy and accessible in any Indian courtroom, and they're quite cheap as well. So you can get one for various denominations, rupees 50, rupees 100, rupees 500. And often once you make the declaration on an affidavit, it has to be notarized. It has to be followed up by a notarization procedure. So on the right-hand side, you see this it's a picture of just a corridor in the Jodhpur High Court in Rajasthan. And the people who are seated in between the pillars are notaries. And notaries are, again, like if you go to any Indian courtroom or any Indian court complex, sorry, you will find notaries just everywhere, right? And so notaries, their job is to take this oath on the affidavit, to have the people who are making that declaration of fact come before them, verify their identities, check that that the content of what they're verifying matches with what they're saying, and just to put a stamp. So even on the document, if you see, there's a stamp of the notary that is there. And so the stamp is put there, and the notary then goes on to document the details in a register. So this is the whole process and procedure. Now, it sounds complicated, perhaps, but it's actually fairly routine. And from what I spoke to with lawyers and from what I understood by interviewing them, it takes less than 20 to 30 minutes to have such an agreement drafted. Because if you look at the copies of these agreements, they're not very long. They're just about 2 to 3 pages, and they very simply state the intent of the couple to live together. They mention the age of the couple, and the entire process can be wrapped up in, as I said, just about 20 to 30 minutes. So it doesn't really take much time. So to emphasize then, the mechanism of making such agreements is quick, it's easy, it's cheap, it's efficient, and once that's done, the agreement is made, right? So now the question arises, though, why I'm emphasizing the quickness, the easiness, and the fact that the process of making this agreement is so easy to access for everyone. And for that, I think we have to start trying and understanding what the purposes of these agreements are and the sort of purposes that they're serving for couples. So in that context, I think, again, one thing that was very critical in my own understanding of this phenomenon was what lawyers told me about who are the people who are coming to make these agreements. Because when we talk about live-in relationships or cohabiting relationships, it's often, there's a predominant sort of narrative in India that these are relationships which only westernized, urbanized, very well-to-do couples are doing in bigger cities, right? If you look at any newspaper commentary around live-in relationship or even judicial orders, that seems to be the primary understanding of who are the people who are doing live-ins. But from what I understood through this process is that actually it's not that entirely. There are many young heterosexual couples who are coming from small towns who enter into these agreements chiefly because they usually in the context of elopement. So maybe there is a lot of familial opposition to the person that they want to have a relationship with, and many of these couples therefore elope. And when they elope and they decide to live together, they do know that unfortunately in India, caste and honor codes are quite strong even now. And so there is a real danger and threat to their lives. And so what couples are primarily looking for in such situations is to have an agreement made which provides some sort of legal documentation of their relationship. And then they can use this documentation to approach the courts to get a protection order, right? In fact, in nearly half of the judicial orders that I analyzed as part of my data set, I noticed that most of them were about getting a protection order from court. And this protection order is simply a writ petition filed in the court by the couple saying that our lives and liberties are under threat from our families and from our communities. So they ask the court to grant them protection of their life and liberty by directing the local police authorities to provide adequate protection to this couple. Now, this doesn't mean that the police actually gives physical protection to an eloping couple. It just simply means that should the families of the couple file any cases against them, then at least they have a remedy that they can approach the police and show this judicial order from the court, giving them protection, and then they won't be arrested. So the purpose of this agreement is not so much about the rights that the couples have vis-a-vis each other. It's not so much about even enforceability. It is a lot about the protection that the couples can get from the court through this agreement. So we see this also reflected not just through the judicial data set, not just through the interviews with the lawyers, but also reflected in the terms of the agreements as well. And what I'll do is I'll primarily take you through some of the key terms that I've come across in these agreements, and that will hopefully build a better understanding of what these agreements are being really used for. So, as I said, the key fact that is documented in these agreements is the age of the couple, to ensure that both the individuals are above the age of 18. And also to document the consensual nature of the relationship, to make sure that there is a term in the agreement which says that the couple has mutually entered into a relationship with they're mutually intentional of entering into such a relationship. right? So that's the common thread across all the different agreements that I looked at. And of course, as I mentioned, the key aim of this agreement is to have is protection from social and familial interference. So I've just highlighted one term here, for instance. So this document has been made so that we can freely go anywhere in India for roaming or staying in any resort, hotel, hostel, public place to stop police excesses and to keep each other safe, provide security, and so that the police and administration and family members of both the parties do not interfere in our private life. So this is exactly what I was saying just a while back. The primary purpose seems to be protection from social and familial interference. Another kind of term that I've seen across several of these agreements is outlining some of the responsibilities that the couple has towards each other. So again, if we look at how this is being phrased, it's as long as I, the first party, and usually in these agreements, the first party is always the female living partner. So that as I, the first party, stay with you, the second party, my maintenance and other daily needs will be fulfilled by you, the second party. And I, the first party, will get rights as an heir to the property of the second party. Any child born in this relationship will be our legitimate child and will get rights in the property of both the parties. So this is also a really interesting term because it's a little vague, as you can probably understand from how it's being framed. It doesn't say what property, it doesn't say how much, or it doesn't mention the other sort of legal liabilities on that property. So as a lawyer, when I look at some terms like this, I can tell that the framing of such a term is very vague and would not hold up in any court of law as an enforceable term. So the point isn't, again, enforceability of these terms, but perhaps as a way to signal the intent of the couple and to sort of suggest to the court that this is the kind of relationship we are in, right? So that's another specific type of term that I see in the agreement. And the third kind of term that I've come across are terms which discourage future criminal allegations. Now, many of these agreements have terms such as this. So I'll just read out these particular ones. We parties will not file any legal proceedings or disputes of any kind against each other in respect of the said relationship. If any party does so, it will be deemed and considered false and against the spirit of this document. And from another agreement, there is this particular clause. It is that if any dispute arises between us parties in the future, then the said dispute will be settled by us at a societal level in the presence of eminent persons of our society, and no action of any kind, including rape allegations, will not be filed against the second party. So the mention of rape allegations here is not a coincidental, not some random feature of this term. And as I found out from lawyers, there's a very specific reason that such terms are included in the agreement. And that's because it seems that not only are these agreements used to protect couples, but specifically they are used as a legal shield for men against quote unquote false rape cases, right? So what do I mean by this? Now, in India, the laws of rape are gender asymmetrical, which means that women can file cases of rape and sexual assault against men, but men cannot do vice versa. So this, and there has been a lot of, these kind of laws have been the product of feminist movements, which have always kind of showed and argued that, yes, there is a real threat to women's lives, and therefore you need provisions such as this, that you need the kind of gender asymmetry to protect women. But over time, this has only kind of resulted in a lot of resentment and this sort of narrative that women do get the upper hand in one way when it comes to laws, and that Indian laws are unfairly tipped in favor of women. And so there is this general widespread assumption, even amongst the lawyers I interviewed, that a lot of the cases that are filed are in fact false rape cases. And because of this sort of problem, this large problem of false rape cases, these agreements are acting as a tool to protect men against these type of allegations. Because what happens is when an allegation comes before the court, lawyers will use this agreement to argue that this was in fact a consensual relationship, and therefore such allegations, criminal allegations of rape or sexual assault are not valid, right? And this, apart from the protection order cases that were part of my data set, these bail application cases were the other major chunk of cases that were coming before the courts, right? And I analyzed these cases to see that in most of these instances where someone approached the court for a bail application, when there was an allegation of rape or sexual assault, the court granted bail. Even though bail in these kind of cases are, these are non-bailable offenses. So in fact, bail should not be that easily available. But bail was nonetheless granted, and these agreements are part of the kind of defense strategy and toolkit that lawyers use to protect men in case there are any sort of allegations made. And just including these type of terms in the agreement perhaps also acts as a sort of mental deterrent for the parties, where they might be under the mistaken presumption that they cannot in fact file cases against each other. So these are some of, so I think maybe this helps us to sort of understand and get a better picture of what the purpose of these agreements seems to be, which is, again, like I said, they're not really concerned with rights and liabilities or obligations, but more about protection, and protection not just for the couple, but also for specifically for men. Now, just go slide. Okay. Now, what is the judiciary's role in all of this, and how has the judiciary been really responding to these cases? Now, it's really, in all of the 369 judicial orders that I looked at, I found that most of the time judges don't even really get into the question of legal validity of these documents. They are not, neither is this a central question in the orders that come before the court, in the matters that come before the court, but also they simply don't pick up on it and they don't really respond to it. So there is a kind of tacit acceptance and toleration of these agreements, but there is no comment really on what the legal validity is, or there's no serious examination of the conditions under which such agreements were made. And that's also perhaps because the kind of matters in which these agreements are coming up, whether it be bail, whether it be protection orders, these are not, the legal validity of these agreements is not central to determining the outcome of these cases. So perhaps that's why the judiciary has also not really made any significant observations on the legal validity of these agreements. There have been a few cases, one or two, where some judges have noted that this is in fact a misuse of legal process, that such agreements are void under contract law. But again, it's not a well-reasoned judicial order. It's not a properly considered position. These are more just observations, and they're too few and far in between. They're just one or two orders. So in a lot of ways, what has happened is that through just tacit acceptance of these agreements, and this kind of repetition, the sheer fact of repetition has made this into a set legal procedure. So now in Rajasthan, at least, where I did my interviews, I could see that this has become a well-established legal practice and not something that lawyers are necessarily thinking that much about, right? And courts also do their part, in either deliberately or not, in maintaining the kind of legal ambiguity around these agreements, right? And yeah, so in effect, what's happened is tacit acceptance means repetition of practice. That practice becomes a kind of established procedure over time. So, which brings me to the final kind of point, is that where does all of this leave us, right? And what does this entire thing mean? And so I am also at that part in my PhD where I'm thinking exactly that question, that what this, what this entire practice means. And for me at least, what I've found is that live-in agreements are an interesting case study because they show how law doesn't always work as we imagine it to work. When we read laws and state enacted laws and formal law, that's not how law works in practice, right? There is an everyday experience of law as well, and live-in agreements are precisely that, and which is what makes it a fascinating case study. And by existing in this type of legal borderland, so I again come back to that metaphor that I used in the beginning, is that by sort of staying on this legal borderland, I think it allows these documents, it allows these agreements to function in various different ways. So the lack of formal legal recognition is what makes these agreements so effective in one sense, right? Because they're because you're able to cut out all the bureaucratic red tape of actually having the state recognize your relationship. You're able to get that agreement made in a quick, easy, and cost-effective manner, right? Which often the legal system in India is not. And using that agreement, you're able to get protection from the state, get protection at least from the some arms of the state at least. But at the same time, this lack of legal recognition for agreements like this also has a lot of troubling consequences, which is, one, we don't know how consent was given in the making of these agreements. We don't know who are the people who are controlling the drafting of such agreements in the first place. We don't know if these agreements are misleading some people into believing that they have rights and legal status under law when they don't. And we don't know if this affects their perception of their rights within the relationship as well. So this lack of legal recognition, therefore, also has a number of troubling consequences. And so I think these kind of borderland legal practices are interesting because they raise a broader question for how formal law should interact with these type of practices, these sort of everyday uses of the law. Should it ignore them as the judiciary currently does? Should it acknowledge and regulate these agreements, or should it discourage them altogether? So that's the question that I am at currently in my PhD, that I'm also trying to think through. And so I would really appreciate your thoughts and feedback and questions. I've really rushed through my entire data, so I would be also happy to just talk through some of the details of how I collected and analyze the data as well. So yeah, thank you.
Thank you, Diksha, for such a fantastic presentation on a very important topic, and I completely agree with you. Not much has been written about it, especially in context where the freedom of speech is limited. Without much ado, I would like to invite our discussant for today's session, Dr. Nishant Upadhyay, Department of Ethnic Studies, College of Arts and Sciences, University of Colorado Boulder, to share their thoughts on Diksha's presentation. Over to you, Dr. Upadhyay.
Thank you, Dr. Riyad. Diksha, that was such a fascinating paper. All the different things that you're pulling together was, I could have continued listening to you for longer. I feel like the details that you were capturing, there's so many things that happen here, right? I really like how you're thinking about Borderland, and I guess in your future work, or as you write, you will probably think more about it, right? But how they're working within the legal and find what legal is beyond that, right? So that really stood out to me. So I'd be interested in hearing more of your thoughts about that. And I'm also so fascinated that this is happening mostly in Northern India, because I would have assumed, as you were saying, public understanding of live-in relationships are more that these are urban couples who are more mobile, have more caste class privileges and whatnot, right? But in a state like Rajasthan, Allahabad High Court and Gujarat seemed like the highest number of these cases, and the everyday politics of caste, gender, patriarchy, and religion, right? Like in these states, is very different from rest of the country, and so I'm really curious of how those factors play into this, especially like a state like Rajasthan, where both, as you mentioned, caste, honor codes, and interreligious marriages are so prohibited, right? So that's one of my questions. So obviously you can't share the names with us, but in your reading of these, what are the caste and religious positions of these people, right? So if when caste, intercaste marriages, I would assume, I don't have the data on this, but I would assume Rajasthan would probably be Rajasthan, Gujarat, UP would be one of the lowest in terms of intercaste marriages, right? State recognized marriages. So and the honor codes in these states, especially in Rajasthan, I would assume are against intercaste marriages, right? And so are these couples trying to defy that? But then also the other question about religion, given that the rampant attack on interreligious marriages across the country, state-sanctioned attack, right? So caste, we can say the state supports intercaste marriages, but societal codes don't. But interreligious marriages, the state does not support them anymore, right? And so all the legal barriers that people have to go through to get into an interreligious marriage. So is this a way that people are finding to disrupt state mechanisms? So just want to get a more sense of, like, through the names, what stories can you tell us about that? And then I'm also curious, and if it's not really legal, are there queer couples who are using this? And would that be valid if the whole if it's not really recognized, then this could be a really good entryway for queer couples to get some kind of recognition, right? And recognition in courts. So I'm curious about that. I was going to ask, where do you think the language is coming from? And it sounds like you're also trying to figure that question, because the language is so stark, right? And all the provisions from traveling to resorts and hotels to rape allegations, like that's I would have thought like housing would have been at the top of the list, to give housing for these couples to get access to housing, which we know a lot of people are not going to give housing to live in relationships, right? And so that I would assume would be the top priority rather than going to resorts and hotels. But I also know, like, at resorts and hotels, you have to show your marital status, right? Especially for straight couples, they have to show that, right? So I'm just curious, like, where do you think are these the notarizing authorities who are coming up with this language, or couples? Like, what is your sense of where it's all coming from? And then I think the questions you ended with thinking about the what kind of rights it gives and what rights it doesn't give. Those are really crucial questions, right? And really excited, looking forward to what you write and what comes out in the PhD to make sense of these things, right? So those are, and I'm not a legal studies scholar, so I can't comment much on them, but from a social science perspective, that is so important, right? Like, especially in these smaller towns outside of the hegemony of, like, bigger cities and urban English educated caste privileged couples, right? And it seems to, reading through Indian newspapers, like, live-in relationships are always in the newspapers now, right? In the last few years, the language around live-in has changed so much, and I know there's been a few Bollywood films about live-in relationships now, and so that the social politics and cultural politics has changing, and there's, like, some kind of tacit, much more approval, I guess, but within the realm of the legality, this is so uncharted territory, right? And as you're talking about, so just, I think it just opens up so many questions, and especially when, like, from a queer studies point of view, like, we know how homophobia, transphobia works in India, but love is so regulated and controlled in India, right? And so I think this is such a fascinating site to explore that, even for straight couples, that how law is so against love and intimacy, and straight couples, young straight couples, especially if they cross the caste and religious boundaries, are sometimes more surveilled than queer couples are, right? Queer couples. So in that sense of how we can understand heteronormativity and heteropatriarchy, I think your project is offering a lot to think about, and really exciting site of analyses. So thank you.
Thank you. Thank you.
Yeah.
Thank you so much.
Thank you, Dr. Upadhyay, for very useful comments. At Diksha, we have two options. So either you first respond to Dr. Upadhyay's comments, and then we go to Lucrezia, or let's go to Lucrezia, collect more feedback, and then you can respond to comments of both discussants and peer commentators. How would you like to prefer?
Yeah, I think I'll respond first, because then I might just somehow forget all the points,
All right.
and so I
Okay.
think this might
Go ahead,
be
please.
helpful.
Yes,
Um,
please.
So yes, on this question of who are the people using it, and what their caste, class, background is like, this was genuinely a very hard thing to get data on, because I was looking at judicial orders, and many judicial orders do not record data uniformly. So in some cases they will record caste, identity of the parties, and in many cases they don't. Sometimes you can try and understand, looking at the kind of cases that have been filed. So if it's under the SC/ST Act, you can the Scheduled Caste and Scheduled Tribes Act, then you can understand that there might have been certain intercaste marriage here. So yes, it's something I wanted to look at, but I genuinely don't think I have enough data to make any claims. But what I did find interesting was, from the 7 agreements that I was able to get a copy of and look at, none of these agreements were actually about intercaste couples, and they were. I didn't come across a lot of intercaste or interreligious couples per se, which is not to say that this doesn't happen. Of course, it does happen, but I didn't necessarily see that in the data that I had. And it's interesting that even if parties are from the same caste bracket, which often is the case, even then there is quite a bit of familial opposition to these relationships. So yes, caste and class are important factors, but and of course there is a lot of social codes around honor that are quite strong in Rajasthan, but I haven't necessarily seen that in my data as of now. But I do think that in general there is a lot of value in, because Rajasthan is such an exceptional case. I think there's a lot of value in trying to look at social demographics of the state and seeing what the state has been doing, to promote intercaste or interfaith marriages, and to see if there are some patterns that emerge with that. But I think we'll have to collect data on a much larger scale to really say anything. About queer couples using these agreements, anecdotally, I've heard of such cases. So they're not, again, recorded. They don't appear in the judicial data set as much. But I have heard from lawyers that, yes, there have been instances where even same-sex couples have made such agreements and have come to court. And in fact, there is such a practice also of signing friendship agreements, which is a whole other thing in another state in India, Gujarat. And I think there are quite a lot of parallels between these two practices. And friendship agreements, of course, is something that arose from a heterosexual context, but was also used and by queer populations at a certain time in the 1980s. But again, I think there are parallels here. But I have heard of queer couples also using these live-in agreements, though not maybe as much. And I think what you pointed out about, is there potential for queer couples using such an instrument? Oh, definitely. I think so, and in fact, that's why I was first interested in such agreements, because I was approaching it more from the lens of, does this mean that, if this is a tool or a legal tool or a practice that is not entirely illegal, but it's not substantively recognized either, is there space for some sort of recognition for queer couples, and is it being used to that end? So I definitely think there's potential for that, although I don't think lawyers who are dealing with this practice on an everyday basis are that interested in trying to forward the legal understanding of these agreements, because that doesn't seem to be their primary concern anyhow. And you're absolutely right about trying to piece together where the language and framing of these agreements come from. I think because I'm also translating from Hindi to English, maybe some of it gets lost in legal translation. I don't know. But yeah, it is. I don't think about why hotels and resorts specifically and not housing, which would have made sense. But if I were to venture a guess, I'd say it's because many times these sort of the idea, I think, as some lawyers explained to me, is that you get these agreements made and then you just try to consummate that relationship. So many of the time these lawyers also they give you the whole, they help you make the agreement, but they also, it's like a packaged business deal is like something that lawyers explained to me. I don't know if I'm doing a good job explaining this at all, but he basically said that, oh, couples want to then go ahead and consummate that relationship. And so, you'll get all of it together for a certain price. So I don't know. It could be something like that. I haven't given it that much thought just because, one lawyer makes one observation. I don't want to make a generalized observation based on that basis. But yes, the question of where the language is coming from is really interesting one to think about just in and of itself. Although I'm not really sure I'll have the answers to that. But yeah. Thank you so much, actually, for your comments. Extremely useful. And yeah, thank you.
Thank you very much, Diksha, for the response. Let's go to Lucrezia. Lucrezia, over to you.
So thank you so much for this fascinating case study. I learned so much, and it was an absolute pleasure to listen to your paper. So I'm wondering, because it's in your title, Navigating Legal Borderlands, Love, Law, and Living Agreements, where is the love part, and how will you analyze it? So, and I think of that especially maybe because you have a case study that is particularly interesting because, as you mentioned, these agreements protect couples, but they provide individuals, they provide protection for individuals within the couple, so from the other, which is always also in marriage a peculiar way to think of care and of love. Especially in cases of elopement where sometimes it's romanticized and we don't want to protect individuals from the other in a romantic relationship. And also I'm super interested in the gender power relationship ambiguity of these agreements, because you mentioned how men are obviously being protected by these rape allegations that cannot be filled against them. But the fact that it is also a matter of legitimating a child and allow them to get rights, make it a possible political use for women as well. So, because I think of it as a possibility to avoid the precarity of celibacy as mothers. And that also leads me to my third question. So you mentioned this possible, that these living agreements can be a form of elopement or linked to that kind of, ratification, or I don't know. And regarding the two terms that you analyzed, do you think that there could be a link with pregnancies? And so that's it for me. I'm sorry about my audio. I still can hear you.
Oh,
we can hear you. We can hear you. Right. Over to you, Diksha, then.
Yes. Yeah, these are very challenging questions. Um, when it comes to the what about these agreements seems to be about love, I think that this it obviously is a couple who is eloping because they want to stay together. So in some sense, I've assumed that it is in fact a romantic relationship. But also, I didn't highlight this in my presentation, but there are also some terms within these agreements where parties do write terms which are somehow framed that, okay, we are going to stay together, we really love and respect each other, we want to spend the rest of our life together. And, so there are those kind of terms that I use. I didn't highlight it because, I would just spend all day here and highlighting all the different ways and terms that are sort of written in these agreements. But yes, there is some invocation of love and expressions of care within these agreements, which also sort of is interesting because in the cold, hard, language of contract law, there's often not necessarily a lot of space, for expressing this sort of language of relationships. So I would be curious to also see like how other cohabitation agreements are framed and to see whether there are similarities there. But yes, I think the love is sort of understated and muted in my research because I have not been able to interview couples. And that was a limitation of my study as well, that it focused mostly on lawyers. There would be a lot of ethical concerns to be able to track and talk to these couples, many of whom are, in fact, trying to avoid the law, right, in a way, and too much recognition, and not too much recognition, but they're trying to avoid being in public limelight. So perhaps it's a question for future research as well, that how couples themselves think about their relationship vis-a-vis each other in the context of these living relationships, and especially with couples who are making such agreements. So yes, I think that's a fascinating lens to look at from in another paper or in another research project. So I think the other question was about the gender power dynamics, right? And whether or not this any implications for motherhood. I don't think I understood that point very well, but if you could just maybe clarify that, then I'll try and give a better answer.
I think it was more a comment, actually. I was mentioning the fact that I think it's super interesting to have this ambiguity of users, and that it was not clearly. It could be also a political use for women to have their child being legitimated. Yeah.
Okay. Yeah. So the thing is, this term is a little superfluous, and the reason it's a bit superfluous is because Indian courts do recognize a child as legitimate, even if the child was not born in a marital context. And so the problem really isn't so much about the child being declared as illegitimate, as an illegitimate child, but it becomes a problem only when the child is trying to access inheritance, not of the parents' property per se, but of ancestral property that might belong to the parents. So it's more of, I think, a challenge in that situation and context. But otherwise, the child is considered a legitimate child. So the inclusion of that term itself is actually very superfluously worded. It is already the case. And yeah, that's that. But I do agree that, having said that, I don't think this is happening necessarily, or at least I don't have the data to say how these agreements are being used in other courts, if at all, because all the data that I've collected are from high courts, state high courts. But it could just be, and I've asked lawyers this, whether such agreements are used in family courts. So say in a situation where a couple has a child in these kind of live-in relationships and they separate, and the woman is left with the child and she has to look after it. So would she be able to approach a family court, use this agreement as evidence, and to claim some rights, some maintenance? That's a question mark. We don't know that because I haven't come across a lot of uses in family court. So that would also be interesting to see. Again, to be clear, the courts don't need these agreements per se to enforce any kind of rights, right? But in the event that such agreements are made, are these courts using it as, are they giving it any sort of judicial weight, as many other jurisdictions do? Even if an agreement is not enforceable, sometimes a court does give weight to what has been written in the agreement and does consider the intent and wishes of the party. So it would be interesting to see if in other courts, apart from high courts and family courts, if these agreements are being used, and if so, whether judges are giving some sort of legal weight to the intent of the parties as found from the agreement. So that's something, again, that I don't have the data set to conclude, but it's also something that can be explored more at a later time.
Thank you, Diksha. We are short of time, but just to quickly pick up one question in the chat box, and that is from Dr. Bishnu Pariyar from the University of Leicester, School of Criminology. And he's asking, I'm curious to learn which party in general does the initiation come from when two individuals get into this sort of relationship, situationship, whatever is applicable. So yeah, which party? Just briefly.
Well, my assumption would be the male party, but again, I don't have enough evidence to suggest this. This is also something that would only become clearer if I actually was able to interview the parties. But even from just talking to the lawyers, it seems that if their intention is to ensure that male parties have a sort of protection in the event that criminal charges are filed against them, I do feel that it's more directed from that end and with that intention. So there's definitely a lot of gender power dynamics kind of going on in how these agreements are framed. It would be really interesting to see if this same kind of dynamics play out in queer relationships, but I'm not sure at all. But yeah, if my intuition and gut tells me, it's obviously coming more from men.
Great. In that case, I can still pick up one question. I mean, I will be happy to entertain one question if there's any question from attendees. Otherwise, I'm going to ask one question, and that is law specific. In that case, Diksha, the question is about the case selection method. So I could see in one of the slides, high courts. So you focused among all, these different tiers of the courts, the lower courts, lower judiciary, where most of the cases, huge population can afford to reach there and, resolve their disputes. Few of them can, have the capacity to go and appeal and then go to the Supreme Court. And then I can understand why there is one case there, which I could see. But still, I mean, I have only two questions. What is the criteria of the case selection method? Because that is very important in these kinds of legal studies where, you are analyzing the legal judgments, and especially of such a huge country where loads of high courts are there, and then Supreme Court, and higher you go, the liberal jurisprudence becomes, lower you go, the conservative it becomes, because of the different composition of the benches and the judges. So I wonder what is the case selection criteria, one, and second, the one case which you analyzed, of the Supreme Court of India, what's that actually about? Because it's very important for two reasons. One, first reason is that it influenced the jurisprudence of rest of the country, is binding somehow, people borrow principles. and it influences that. And also it has a regional effect. Second reason is that the other countries within South Asia, they usually borrow all those principles. So it becomes very important, even if it is one judgment. So if you briefly could summarize what was the upshot of that.
Yeah. So let me start with the second question first. So the order that came up in the Supreme Court, if I remember correctly, was a bail order, and similar to the ones that have been coming in the high courts, and similar to what I've been saying in the presentation as well. And there was nothing very significant at all in the order. Otherwise, I would have delved into it a little bit more. But the court simply said that, okay, the applicant has filed for bail, the applicant has filed a live-in relationship agreement, and I can't remember whether bail was granted or not. I can't remember the specific outcome of the case, but it was simply, there was no observation at all on the live-in relationship agreement or its validity. So there's nothing from the Supreme Court or the Apex Court about such agreements either. And as far as the case selection criteria is concerned, so do you mean why did I select cases in Rajasthan, or why did I select cases in high courts in general?
Yeah, first the number, the sample size, and then also these different cases. Was it like you if there was one criteria like diversity, different places that determined these high courts, or there were other factors as well?
Okay. So again, a lot of this is to do with what data is actually available, right? So I looked at the Indian Qanun portal to find the judicial orders, and I also kind of looked at Manupatra and other databases to see where these orders are coming. Now, all of these databases only keep high court orders mostly. There are on the Indian Qanun website, there are some district courts as well. There's some orders of district courts available, but one, I didn't find any district court orders on this, and second, I mean, I found a few, but not a lot. And secondly, I think my supervisors and I just decided that if we're looking at high courts, then we should only look at high courts. Then because we just don't have enough of a data set to be able to look at district courts, and therefore at least we have data from all different high courts, but we have data from only very selective district courts. So it made more sense to go with the data that was available in greater abundance. And so I searched on these databases with specific terms, and wherever I was able to find live-in relationship, deed, live-in relationship, agreement, and they were, essentially used together, those were the cases I was able to highlight, select, and analyze. So whatever cases I found which mentioned a live-in relationship agreement, it just became part of my data set, which doesn't mean that there are no other cases or, that this is the complete set. It just means that these are the set of cases that I was able to locate on Indian Qanun on Manupatra till a certain cutoff date. It could also be, and I do acknowledge this somewhere in my work, that perhaps the terminology of these agreements might be different across different states. But so far, I haven't come across something very significant. But yeah, that was roughly my case selection criteria.
Thank you, Diksha, for your insightful presentation. The project clearly seems to make a valuable contribution to the broader literature on law, courts, and live-in relationship. It's a very clearly very niche area, as you mentioned, that not much has been written about it. So many thanks to Dr. Upadhyay and Lucrezia for useful comments, and to everyone who attended the session. The Global South Network warmly welcomes PhD students from any discipline and any part of the world to share their projects and receive interdisciplinary feedback. Anyone interested in presenting their work or participating in a session during the International Interdisciplinary PhD in Progress weekly seminar series, you may feel free to contact me at the email leicgsn@gmail.com. Same time next week, let's meet our next guest speaker, Bhargavi Harshal Shah, PhD candidate, Faculty of Law, National University of Singapore, who is going to present their PhD project titled The Legitimation Strategies of the Reserve Bank of India on 27th of August from 3 to 4. Until then, take care, look after yourself, have a wonderful day. Goodbye.
Right. Thank you. Bye-bye.